SwayamPrabha. Digital India. Educated India.
Good morning viewers, this is Dr. Ashwini Siwal from Faculty of Law, University of Delhi. Today we are going to discuss a very important topic in the series Law, Science and Technology. This topic is about digital realities in the virtual space or in the digital space, which are definitely intruding into our day to day lives. And this lecture is on augmented reality and on virtual reality and the laws relating to augmented reality and virtual reality. The lecture number is basically 10. Well, viewers, you all know that these digital realities these days are having multifarious ramifications as well as usages. We need to understand their contours, their operational modus as well as the law relating to it. As a law teacher, I think that the digital realities should not go untamed or should not be unfettered. There should be regulations, and there are definitely regulations about the augmented reality and virtual reality, but are those regulations available in coherent manner, or are those regulations available in a concrete shape or not? This is what we are supposed to discuss today. And I also discuss what are the different laws or legal questions that arise with the use of these digital realities or digital technologies, which are called augmented reality and virtual reality. Well, in the first attempt or in the very few basic slides, I will try to explain the nature and the definition of these realities or these technologies, and then we will delve in deeper into the legalities involved slowly. So, coming to types of digital realities, as I told you that there are two which we will gonna discuss specifically, that is augmented reality and virtual reality. Well, so far as the augmented reality is concerned, it is designed to add digital elements over real world views with limited interaction. Well, this is a technology which is designed to add digital elements. It adds digital elements into your perception through the electronic devices, and it has a limited interaction with the outer space, you may say. It creates some digital elements in the environment which you may see on your electronic devices, say a portable phone or a portable computing device in the form of a mobile phone. Virtual reality, on the other hand, is an immersive experience, and it isolates the outer world completely. The user of the virtual reality enters into a virtual sphere where he is totally isolated from the real world or the physical world. Whatever he sees, perceives, looks is virtual, but it is an immersive experience where he gets totally immersed, his whole senses gets totally immersed, and it may be used or it is used with the help of certain ancillary technologies or some ancillary gadgets like headphones or like headset devices, because that takes you to a virtual world. On the other hand, in the case of augmented reality, you stay in the physical world, you are very much in the senses that you are in a physical world or you are standing or sitting somewhere, but it adds some digital elements into your perception on your electronic device, say a mobile phone or any other electronic device for that matter, and you either mark those digital devices or sometimes these are unmarked. we will explain it later, or we will have some examples later. Then we have another important technology called mixed reality, which is a combination of AR and VR, and here the digital objects can interact with the real world. So, here the interaction is also there, because there are digital objects of the augmented reality which are interacting with the real world, means businesses can design elements anchored with a real environment. So, this is a reality where or a digital reality where both the preceding realities are taken together or are mixed, and it is giving us altogether a different experience. Then we have extended reality, that is XR, covering all types of technologies that enhance our senses, including the 3 types previously mentioned. And this extended reality or a technology basically covers all types of technologies discussed earlier, that is augmented, virtual and mixed, and it enhances our senses, and it includes all 3 types previously mentioned. We have another technology, that is immersive reality. This immersive reality is also called immersive technology, which creates an immersive experience for user. It is a reality technology that either enhances or replaces a real life environment with a simulated or virtual one. Immersive reality can either be virtual reality, augmented reality, mixed reality or extended reality. This is a technology which creates immersive experience for users, and this technology enhances or replaces a real life environment with a simulated or virtual one. Here we have the mix of all 3 or all 4 previously mentioned, and it is also a, you may say, extended version of the previous technologies, which is immersive in nature, which enhance our senses through simulation, and it enhances our senses into virtual space, completely giving us a different experience altogether. So, when we use these technologies, or when any business organization or a company uses these technologies, there are bound to occur some legal issues, which I am supposed to discuss here. And I am since a law teacher, so if I might have spoken something technically something not so correct about these technologies, then I extend my unconditional apology at the outset. But my role here is to discuss about the legalities involving these technologies and understand the legal nuances revolving around these technologies and during their usages. I try to explain these with some examples. When it comes to augmented reality, it is designed to superimpose digital elements onto the real world, and it uses sensors to understand the world around it, and it is a combination of GPS, gyroscopes and accelerometers, and this can figure out where a user is and what direction they are facing. So, this is a kind of technology which superimpose digital elements. It brings in some digital elements into your view or into your perception, and they bring them into the real world, right, as if you yourself is watching that and it is actually available there. So, the example of it is Pokemon Go, which is a phone app which became very popular. It allows players to locate and collect Pokemon characters that pop up in the real world, like in the park, in a living room or on the sidewalk. So, whosoever has played that game knows or must have experienced that this digital component in the form of a Pokemon Go may be popped up anywhere or may be traced by you anywhere, even in your living room, when you are playing it in the living room or when you are playing it in the park. This character will appear somewhere and you are supposed to, according to the model of the game, you are supposed to nab that particular Pokemon Go or track it, right. And it helps, it is basically operated, or it is operational with the help of definitely other ancillary technologies like internet as well as GPS, etc. TikTok even also got their AR filters via their software called Effect House, and this software allows creators to make filters that immerse users into worlds like a European art museum, or even walk around with the popular shark in the sky filter. So, TikTok also got AR filter, which is very popular, which was became which became a rage or very popular amongst the youth, that is called Effect House, which is based on definitely augmented reality. What are the different types of augmented reality? As I told you earlier also, that sometimes digital components are marked and sometimes they are unmarked. So, there are several kinds or types of augmented reality. Marker based AR, it is triggered by physical photos or markers captured by smartphone cameras to place the digital components on top of it, right. There are markers, and smartphone cameras may mark those components on top of those cameras. These markers can represent an object or visual component like a logo or a QR code. Then marker less AR is a complex and does not rely on markers and instead allows users to decide where to display the content. So, this is another type of AR which allow the user where do they want to display the particular content. But in the case of earlier one, physical photos or markers captured by smartphone cameras are to be placed, or you may say are to be put on the digital components are to be put on a particular marked location or onto a particular marked or a captured location, right. The devices use a recognition algorithm to look for patterns, colors and similar features to determine what an object is. The device will rely on GPS, accelerometers, camera, compasses, because with the help of all these ancillary devices they superimpose an image with the real world surroundings, right. Then what is virtual reality? Coming to virtual reality, it is an immersive experience that isolate users from the real world, usually with the help of a headset and a headphone, and it takes you to such immersive experience which you believe that you are cut off from the real world or from the physical world, and your all senses will be able to be incorporated in this experience. Instead of incorporating things into the real world, it replaces the all together the real world and places users in completely new world. So, it may take you to a wonderland, to a Jurassic Park virtually, and you yourself shall feel as if you are present physically with all your senses alive and into a real physical, you may say Jurassic Park, or into real physical wonderland, right, or into real physical sky tower, right. So, this is completely immersive experience which cut off the real world totally and takes you into a virtual world, or you may say takes you into a completely new world altogether. This technology allows user to use computer automation for a 3-dimensional experience, and you also get a 3-dimensional experience here, as if you yourself are touching an object, you yourself are present there and sensing things. VR combines hardware like headsets, controllers, treadmills and software like game engines, content management and training simulators to create the full experience. The two main features of VR are immersion, you get completely immersed, which works by cancelling out the physical world and fully placing user in the virtual world. Second feature is interaction, which elevates the immersion experience by allowing users to control elements. So, here in the second element you get completely immersed with interaction with the physical objects in the virtual world, or virtual objects, but you feel as if they are the physical objects in the virtual world. So, immersion is one feature of the VR, and interaction which elevates the immersion experience is the second feature of the VR. What are the different types of VR? As we saw in the case of augmented reality, there are two types, marker or markless, but here there are few types of virtual reality. Non-immersive VR, it uses the video game console or computer to create a computer generated environment. allowing users to control activities without direct interaction. And then we have this may be exemplified in video games where characters can be controlled without direct interaction. So, it is like a gaming console or a computer where you do not get completely immersed, you just play a game and control the characters without direct interaction. You do not interact into that virtual world, but you are playing with a non-immersive experience. Then we have semi-immersive VR, which offers a virtual tour in a virtual environment without physical surroundings, allowing users to experience a virtual world without physical sensations. Then we have fully immersive VR. It offers a realistic simulation experience incorporating sound, light, olfactory sensations. So, there are fully immersive VR games or fully immersive VR experiences which people are having these days, where even you will smell the particular fragrance of a flower, and you are visiting a garden or a public park, sitting at home, you get such experience as if you yourself has visited the park, you yourself has visited the particular public garden or a mall for that matter. You have touched the things, or you yourself feel by sensing the things, touching the things, even smelling them, right. It is confined away from physical surroundings and uses equipment like body detectors, VR heads, gloves and sense detectors, right. And this VR is popular in virtual gaming zones where players compete against each other, and you feel even the mild pain when you play say a wrestling game, right. This give a sensation of a pain also to you. And these technologies basically work with some related technologies. Without these related technologies, these cannot work. What are those related technologies? Let us have a look at the related technologies. The first and the foremost is the 5G and edge computing. These are the vital infrastructure for extended reality experiences, and fifth generation mobile phones or networks basically will bring not just high speed connectivity, but also facilitate edge computing, which is a form of cloud computing that brings digital content and computing resources closer to a user. This reduces latency, which is important for immersive XR and could facilitate the introduction of lower cost, low weight wearables like AR glasses, right. So, these are related technologies which are used. AR cloud and point cloud is a persistent digital content layer that is mapped to objects and locations in the physical world, providing a digital legend to annotate objects and places in the physical world. For example, Niantic, the developer of Pokemon Go, developed a shared real world platform, right. Then smart glasses or digital eyewears, and sometimes spatial computing is an umbrella term for technologies that understand the physical world and can communicate and navigate through those spaces. Computer vision is a field of artificial intelligence, is also used. So, with the help of these related technologies, AR VR is growing leaps and bounds and is making at times it is making the life thrilling, and at times it is making a life very problematic, because there are some real time law issues or legal issues which have a reason or which are arising because of the usage of the AR and VR technologies. We see their applications in lot of fields like archaeology, architecture, urban design and planning. We see the application of AR VR on education and training. People are having online classes, giving you the real time experiences as if you yourself are in the laboratory conducting the experience by holding the particular chemicals, or by holding or wearing the gloves in the lab, and everything you do in the real time sitting at home. And this is helpful because it brings lot of researchers together sitting across different jurisdictions and yet you can learn from them and share your workspace with them, right. These have become possible with the help of AR and VR. And industrial manufacturing etc. or is also a sector where we see the application of it. Commerce, literature, visual art, fitness, human computer interaction, remote collaboration, emergency management, social interaction, video games, industrial design, healthcare, flight training, military, navigation, workspace, tourism and sightseeing, right, translation, music. So, you have application of VR and AR in several sectors. Some of the sectors as illustration are mentioned on your screen, where AR and VR is applicable and has been tried and tested, and it works very well in all these sectors or in the cases of all these aspects, and sometimes even healthcare planning is done through AR and VR. Sometimes education is imparted through AR and VR. Sometimes even trainings are given, like training to a flight pilot, or training to a military pilot is given, or Air Force pilot is given through AR and VR, and his parameters are tested sitting at the normal laboratory. But what are the legal ramifications of all of these? This is the question that is the foremost and the most important question, which I am here to discuss in great detail as a legal researcher and a scholar. Like most technologies that affect multiple industries, the broad use of AR and VR represents a number of legal and tax issues. There are lot of issues. The following are the legal ramifications. Let us quickly have a look at the legal ramifications. First and foremost is the intellectual property right issue, then data protection issues, then we have e-contract issues, then we have jurisdictional issues, right, and we have taxation or virtual assets, we have crime in AR and world, in VR world. So, we will see all the issues or all the legal issues one by one in the following legal fields, be it intellectual property, taxation, data protection, e-contracts, or determining the jurisdiction in the cases of violation by AR or VR, right. So, let us begin with the first, that is intellectual property. Well, what does intellectual property mean? I hope that viewers are aware that intellectual property means the product of your intellect or the creations of your intellect, which you create, you produce with the application of your mind, with the application of your skill. Even these technologies like AR or VR or these digital realities, they have been invented or produced by the application of the mind or with the application of the intellect. So, there may lie a intellectual property protection on these things if they prove to be novel, if they prove to be worthy enough to be conferred a intellectual property protection. But we need to understand what sorts of or what forms of intellectual property may be conferred on VR or AR. So, for that we must have the preliminary understanding of different types of intellectual properties. Well, my dear viewers, so far as the intellectual property regime is concerned, there are 8 kinds of intellectual properties which are recognized. The first and the foremost for the purposes of this particular lecture is patents. We have then Industrial Designs Act, we have then copyright, we have then trademarks, we have then integrated circuits, we have trade secrets and many more. But these 5 I believe will definitely get attracted or will definitely be invoked in the case of usage of the intellectual property or in the case of the VR and AR technologies. As I said that these themselves are technologies which are evolving and which have evolved by the application of mind of the mankind or with the application of the human endeavor or intellect. So, they must also be given a intellectual property protection, but where and how you may get it, and then which particular intellectual property you must sort for for the VR technology invented by you, for the AR technology invented by you. These are some of the questions which we are going to discuss in great detail. So far as the AR and VR IP right come in two categories, real world IP rights in the virtual world, virtual IP rights in the real world. So the first category, where real world IP rights you see, real world IP rights, as I discussed, patents, copyright, trademark, trade secrets, or integrated circuits, designs, right. So these are the real world IP rights which may be conferred to you because you have created something in the virtual world. On the other hand, you have second category here, virtual IP rights in the real world, where you have a right, or supposedly you must be given a right for a virtual creation in the real world. So we will discuss both in a great detail with an example. So so far as the first category is concerned, let me give you an example of the real world IP where the McDonald's has trademark on its brand in the real world. We all know that McDonald's is a brand name and it is a good trademark of a organization or of McDonald's, which is basically a very popular food outlet across the world. But what if someone depicts a McDonald's burger or restaurant in a virtual world? Does trademark registration stretch to cover everything in a virtual world? Now somebody depicts a McDonald's burger or restaurant in a virtual world. Somebody who just creates a virtual perception of a McDonald's or its burger or brand or the trade dress of McDonald's in the virtual world. So will the trademark registration stretch to cover everything in a virtual world? This is a great question, or is a complex question. Who will gonna own the intellectual property on that trademark created in the virtual world? Will McDonald's have, who is the truly the owner of the trademark, who is having the physical trademark on the food products sold and restaurant services of the trademark of the McDonald's, or somebody else who has created it in the virtual space will get the trademark protection. Then second category is virtual IP rights in the real world. For example, when you design an app that geotags a building, and when you view the building through smartphone, right, you view the building through your smartphone, you have created the building by geotagging it. The app augments that view with information about the building such as height, number of tenants, etc. So who owns the rights when you overlay information virtually onto a real physical object, right? Who will own the protection of intellectual property on that particular work, which is what information, overlay information which you have virtually put onto a real physical object. This is something innovative which you have done. You have designed an app that geotags a building. I just have designed an app. If I look at particular building through that app, right, and my smartphone or through any other camera I am looking at it, this app augments the view with more information about the building, like how many people are staying in that building, how many rooms are there in that building, how many corridors are there in the building, what is the height of and the dimension of that building. So who will own the right on this kind of a work, this kind of an invention? And this is a good example of virtual IP right in the real world. So these are the two kinds of intellectual property intellectual property issues which are arising or which may arise in the case of AR and VR technologies, but we need to get the answer to these. At the moment there are no effective laws as to who will own such rights. Owners of landmark buildings might want to own those rights, of course. If you are in a IIT building at Kanpur, so that IIT Kanpur building is government building, so government will assert its right on the IIT building. but today they cannot control who represents information about their building in an augmented reality application. So, they have no control who will gonna invent something, some technical tool, and then he overlays that information into that photograph or into that mobile application by just clicking a picture of that mobile, by clicking a picture of that building or that particular product. So, these are complex issues. The other thing is an issue that is normally sorted out by contract laws, but is still considered a grey area. Users can design and build things virtually. Say someone comes up with a really incredible and exciting design for a building or a city. Who owns the right to that design? That is normally spelled out in the terms and conditions users are required to sign. So, if I have say created a particular game where lot of buildings I have designed, right. So, who will gonna own the design right on that building? Will I get it, or will other people tomorrow be free to design the same building in the real world, right? These are the question. I have done it only in the virtual manner, in the electronic manner. I haven't yet created a physical building on which I am asserting my right, but will it allow others to use the design of the building created by me in the VR or AR and freely make a physical building on the basis of the design or replicating the design? But as I said and as I have written that such things may be easily handled by contractual terms and clauses, and in the VR application which you are using, sometimes the terms are categorically clear that any designs made of anything, be it of a gun or of a building or of a apparels of the players playing in the VR games, it is clearly or categorically written that they are not to be copied by anyone, and the makers or producers or owners of that game, they own a particular intellectual property on those designs or on those works. So, two important issues will arise. Firstly, whether the protection under the current regime can accommodate IP created in the virtual world, and secondly, whether real world IP proprietors have any legal recourse if infringement happens. So, these are the two important issues. If I simplify for you, first is that whether the protection under the current regime can accommodate IP created in the virtual world. If I have created a design of a building, whether the present regime supports me to get a copyright or a patent or any other property protection on the same. Second issue is, what if there takes place an infringement of some IP proprietor? Do they have any legal recourse to institute the legal action of infringement against the VR or AR makers or creators, right? These are some technical issues that are arising. Then let me tell you that there may arise the issue of ownership of the copyright in the case of AR and VR technology, and under the Indian Copyright Act, copyright basically subsists on original literary, artistic, dramatic works, cinefilms and sound recordings, and a computer program is treated as a literary work and is protected as such. So, AR or VR is basically based on a computer program, and it is a literary work in the copyright or in the context of intellectual property right. It is a copyrightable work. Source and object code constitutes a computer program that is essential to the creation of an AR or VR software, and therefore, such software will be protected by copyright laws once created. So, we have an answer to this question in a very explicit manner, that copyright protection shall be conferred on AR and VR software, because they are the source and object codes which constitute the computer program basically, and computer programs are literary works in the eyes of the copyright law. Indian copyright law requires that in order for a work to qualify for copyright protection, it will have to meet the skill and judgment standard, and this standard was upheld by the Eastern Book Company, or you may say was developed by the Eastern Book Company versus D.B. Modak and others. And this standard means what? That there lies some skill and judgment, and that the person who has created the particular work, be it a source code or object code, has applied some skill and judgment, and the offshoot of that skill and judgment is his work, and it is neither copied nor substantially taken away from someone else's work. It has originated from the producers of that work basically, right. So, if somebody does a substantive variation and some trivial variation, then in that case it may still qualify for a copyright protection, because the threshold of the protection under the copyright law is minimal originality, or you may say is modicum of creativity. A slight amount of creativity is required. There is no requirement of very great novelty or very strenuous novelty in the case of copyright protection. So, ownership of works created using VR and AR technology, these essentially are based on a combination of user input and the artificial intelligence fed therein, and Copyright Act under section 2D provides that the author in relation to any literary, dramatic, musical or artistic work which is a computer generated is always the person who causes the work to be created. So, 2D of the Copyright Act, especially 2D6 of the Copyright Act is most important to understand, that in the cases of computer generated works, one who causes the work to be created, is the author of the work, right. And few jurisdictions such as the United States have recognized that when aesthetic copyrightable works are created using AR and VR technologies, it is the most proximate contributor to the direct expression of the work who will be given copyright protection. So, whosoever remains the most proximate contributor in the cases of works which are aesthetic works, or you may aesthetic copyrightable works. Aesthetic means something that is aesthetically very good or looking very good, a design or an impression. So, anything which is aesthetic and which is aesthetic copyrightable work. So, in that case, if that work has been created by VR or AR, who shall own? According to US law, the person who is the most proximate contributor to that work. Here in India, we say one who causes the work to be created, right, and in US they say most proximate contributor to the direct expression will be given the copyright protection. So, it is the person, the scientist or the engineer who applies the AR or the VR technology to come up with the aesthetic copyrightable work, who will gonna get the copyright protection, because he is the most proximate contributor to the creation of that work. And in the Indian context, the language is very easy. The legislative language reads that one who causes the work to be created shall get the copyright protection. Then there are a couple of derivative works also. Example, a poster painting captured by the AR software, and in the case of, specifically in the case of AR, we know that it just put the digital objects in the real world. So, what if in the case of a AR software some poster or a painting gets captured, right. So, what will happen in that case? What about that derivative work? As nothing actually changes on the physical poster or the painting, the question of whether an infringement has occurred depends on how much of the original poster or painting was reproduced within the computing world in order to create the effect. And what happens in the case of AR, you create a virtual effect into the real world. You are in a real world where you have, say, created the Pokemon, right. You see a Pokemon, or for example, in the real world you see a painting, you see a poster. So, while creating that AR, what if the person who creates the AR software or has created the AR software captures some painting or a poster or a character which is owned by a third party? A third party is owning these. It is also a work of a third party. Picasso's painting gets covered in the AR software. So, what will happen in that case? Will this amount to infringement, or such creation of such effect will amount to or tantamount to infringement, or it will not amount to infringement? The case of Eastern Book Company may be handy here, because it has held that the work that has been originated from an author and is more than a mere copy of original work would be sufficient to generate copyright. The courts have only to evaluate whether derivative work is not the end product of skill, labor and capital, which is trivial or negligible but substantial. The courts need not go into evaluation of literary merit of derivative work or creativity aspect of the same. So, in the cases of the derivative works like a poster or a painting which have been reproduced while creating the effect, the courts, Indian courts, speaking through many cases like Eastern Book Company versus D.V. Modak, has categorically said that the courts have only to evaluate whether derivative work is not the end product of skill, labor and capital, which is trivial or negligible but substantial, and they need not go into the evaluation of literary merit of the derivative work or creativity aspect of the same. Hence, as long as the work created through the AR or VR technology is not a mere copy of what was already available, and the user imputed enough skill, labor and capital in the creation of the work created in the AR VR would qualify for IPR protection. So, any image which gets captured and you use it to create a particular effect, but you have brought a say creativity into that, any poster which gets reproduced while creating a particular effect, but in that poster you have brought a creativity, or you have applied some skill, and that is enough skill as an input given by you, then in that case IP protection will lie to you. Otherwise, if you have substantially reproduced it or you have verbatimly reproduced it, you may be held liable for the infringement of the copyright of the person whose work it is. Copyright infringement is in an AR or VR world. Basically, the Supreme Court in R.G. Anand has held the two works in question need to be examined from a holistic perspective, and to judge the look and feel of both works in questions of copyright infringement. So, this is a test of copyright infringement which we have got from this judgment, that the two contentious works, right, which are in contention before the court of law, and their you may say copyright ownership is to be decided, they need to be examined from a holistic perspective, and the test is look and feel of both works in question of copyright infringement. And if there may be instances where real world copyrighted works such as images, buildings or even statutes are captured in the virtual worlds of AR and VR. The question which then arises is whether such use of copyrighted work would result in copyright infringement. The legal principle of de minimis essentially refers to a trivial legal violation, and in the case of AR and VR, the person may in his or her defense, the creator of a AR or VR, in his or her defense may say that he has just minimally used the someone else's work, or reproduced someone else's work, and because of the theory, because of the principle of de minimis, he may be given the pardon, or he may not be made accountable. But what if he has crossed the de minimis category or threshold? So, in the AR and VR world, the same would need to be evaluated on a case to case basis depending upon the actual test of infringement. So, the courts will have a look and try to feel, and the look and feel test will be applied by the courts of law, and if they feel that the particular work in question in contention is something which is beyond de minimis, something which has been replicated or reproduced in not just in a de minimis way or not just in a minimal way, then they may be held liable for the copyright infringement. So, there are some issues relating to assignment of AR and VR. Assignment is a transfer of a copyright, right? You transfer the copyright by way of assignment or by way of a licensing. So, during the assignment of a AR or VR technologies, ordinarily for audio visual work, the ownership of a content lies with the creator of the content, but in the AR and VR world, the attribution of ownership for IP created in a virtual world is a complex issue, right? In the AR and VR world, how will you gonna attribute the ownership of a IP created in a virtual world? Some IP or intellectual property has been created in an intellectual world, and you want to transfer that technology to somebody, assign that technology to somebody. How would you attribute the intellectual property? Whom you would attribute that intellectual property? Will it remain with you, or you will gonna assign it wholly to the assignee who is a transferee, or who wants to take that technology from you? So, any IP or any intellectual property created in this manner in a virtual world will be determined on the basis of the contractual terms, as well as the conditions set out by the two parties entering into assignment of any such thing, right. This is especially true due to the fact that all the code permitting the creation as well as the creation itself may belong to the platform. Any work created by a user of the platform would therefore be inherently intertwined with the platform which enabled the creation of the work. The terms of use of such AR/VR platforms will have to be drafted appropriately to provide for the assignment of these ownership and usage rights. So, as I said that terms of the assignment agreements have to be kept or have to be made in such manner that you keep the intellectual property with you, and you do not give up your intellectual property during the assignment. If you want to give up, then you appropriately charge for the assignment of your intellectual property from the assignee, because it is a intellectual property created by you in the virtual space. This will be done pursuant to the fact that in the event the platform shuts down, and it becomes more complex when the platform on which this VR is created by you shuts down, right, or access to the user account is terminated due to any reason. Will a user be denied his intellectual property, especially if the user is monetizing his intellectual property in real world currency? So, this becomes very complex. Platform owners are different than VR technology creators, will they own or not own, it depends, because sometimes the platform owners may shut down their business, may terminate, may even deny the access to the subscriber of that platform. So, what would happen with the intellectual property which has been created by you on the platform, right, and you have applied your skill and judgment in creation of that intellectual property in the virtual world. So, these are the few things or complex issues as far as the copyright is concerned. Now, coming to patents, another intellectual property which also comes into consideration when we talk about the AR and VR. We have understood the the copyright issues in the AR and VR. Now, we will talk about the patent issues in the AR and VR. What are the patent issues? Well, filing of a patent in the case of a AR and VR is definitely not different than any other computer program. We all know that computer programs are basically copyrightable in India, but in India software patents has started recently, and computer related inventions are also given a patent protection in India. So, filing of a patent, the procedure etc. is same, right, and so far as the AR and VR is concerned, it is what it includes various items such as systems, maps, data, business methods, features, functions, processes, and it is a patentable subject matter. There may be a process which you must have created, there may be a some business method which you have created. In India, business methods are not patentable, but in US business methods are patentable, and you are doing a business through AR or VR. So, you may even obtain a patent protection on the same. In India, the law governing patents is the Patent Act 1970, and whether AR and VR technology would be eligible for patent protection in India is a question which may hinge on the determination of patentability of software or computer programs. And as I said that it has started, and as I said that they are copyrightable too. So, some form of intellectual property is available even to the computer programs. So far as the Patent Act is concerned, under this law, computer program per se are not inventions, and it has raised a debate whether a computer program with any additional features such as technical features would be patentable. Section 3K of the Patent Act has maintained that computer program per se is not an invention. The Act had created an exclusion of certain computer programs. Computer programs in its technical application to industry and computer programs in combination with hardware were identified as patentable invention, as computer related inventions, or shortly called as CRIs, right? They are shortly called as CRIs. So, anything which is created by a technical application in combination with hardware, right, is a computer related invention, and it may get a copyright, so it may get a patent protection in India. So, in the Patent Act, computer programs per se are not patentable, but anything which is a computer related invention may get a patent, and we have instances. Our Indian Patent Office has conferred a patent protection on even softwares and on computer related inventions which have some features which are followed by hardwares, etc. Therefore, prima facie patent applications for AR VR technology coupled with hardware features should qualify as patentable in India, subject to meeting other required criteria, which is that there has to be novelty, there has to be non obviousness, and there should be utility, right. These are the three requirements which are to be fulfilled so far as the patent qualifications are concerned in India. We have some trademark issues also in the AR and VR technology. What are those trademark issues? Let us have a quick look at those. Use of AR in advertising, right, and a more developed customized usage may make brands be prone to trademark dilution. What does trademark dilution mean? It means that by uses of a deceptively similar or confusingly similar trademark, you dilute the distinctiveness of the existing trademark. You dilute the distinctiveness. So, use of AR in advertising and a more developed customized usage may make brands be prone to trademark dilution. AR and its developed customized usage. We know that AR is used in advertising, and people are making brands, by customizing the AR technologies, or by using the AR technologies which have some features of customization. So, while doing so, they may tend to dilute someone else's trademark, which may land you into trouble, because what happens in that case, the association of visual created in the AR world with a pre-existing trademark has potential to cause blurring or tarnishment of the pre-existing mark, which will give rise to claim of trademark dilution. And even in the case of trademark dilution, you just not have blatantly caused the deception. You have created such a trademark which is making or paying a way for the association of your trademark with the existing trademark. So, mere association created visually by you through your AR tool will land you into trouble, because it may amount to trademark dilution, which is an offence. As per the Indian Trademark Act, the test to see whether a trademark has been infringed is whether there is a likelihood of confusion for a consumer with an average intelligence of imperfect recollection, and to believe that the use of trademark is associated with the owner of the trademark, right. Hence, trademark law should give the owners of the trademark the right to exploit their trademarks in the AR VR world in relation to goods and services for which they have obtained such registration. So, only owners of the trademark have the right to exploit their trademarks, but if somebody else wants to use those trademarks in the AR and VR world, then these people have to obtain the consent from the trademark owner to do so. Otherwise, if they are doing it, then they may be held liable for the infringement of the trademark. Then we have some data protection issues in the case of AR and VR technology. They rely significantly on data which is either supplied by the user or automatically acquired. right? Data security and privacy issues become more prevalent because of the intrusive nature of these technologies. Anyone's data may be taken. Here, in the living room, what sort of things you keep, what kind of television you have in the living room, which refrigerator you have in at your home, which brand's television your living room has, everything may be, every information about you may be taken away by a person who has provided you with a AR or a VR technology which you are using for playing a game like Pokemon Go, right. Businesses in this sector will face numerous challenges in complying with existing and newly introduced data protection law and GDPR, right. So, everything like location, body, head movement, biometrics, payments, bank accounts, conversation recording, video recording, etc. are some of the forms of data which is collected while using AR and VR technologies. So, sometimes it is collected with our consent, sometimes it is collected without our consent. So, we have to the creators of the VR and AR technologies are required to be aware that if they take away our data, then they must comply with the Digital Data Protection Act norms, and they should not use our data without our consent and without the stipulated and specified purposes as mentioned into their terms and conditions, right. Then this data sometimes transfer to the third parties, which heightens the risk of hackers accessing such data and leads to some ill consequences, right. These third parties they generally process our data without our consent, and there are several risks which are associated. We have a current data protection regime which is excellent, which have got some answers to this problem, but I won't discuss it because I have discussed these things in one of the lectures. Rather, I will prefer to discuss some issues pertaining to e-contracts, like when you use the AR and VR technologies, you are governed by the Indian Contract Act because you enter into a e-contract. It is important to note that the IT Act also recognizes the validity of the e-contract, and the Consumer Protection Act introduces the concept of unfair contract, which may help if somebody has entered into unfair contract with you, because sometimes their terms are very lengthy and cumbersome. You can't and you generally don't read those lengthy and verbose and heavily worded terms, and you don't understand. So, AR and VR players would need to keep these principles in mind while drafting any Indian consumer facing contracts, that they need to be simple. Jurisdictional issues are there. We have examples of really global technologies in AR and VR. Depending on the application, any player from anywhere in the globe can connect to these augmented or virtual worlds and engage in a variety of activities, some of which may be legal or illegal. So, AR and VR realities include being subject to such dynamic jurisdictions. So, we have people offering AR and VR technologies or games to us from other countries, and when any crime or when any infringement takes place, so where should the exact or appropriate jurisdiction lie in the case of any contention which arises out of that bonding or that association. So, we have a case law called Bragg versus Linden Research. In this case, the US Federal District Court ruled that the district court had personal jurisdiction over a non-resident operator of a massively multiplayer online role playing game, in which the avatar of the user could engage in virtual business transactions with others and own property. It was held that the court had the jurisdiction to try the suit, right. The court unfortunately did not have the opportunity to rule on the substantive aspects of the suit, as it was settled out of the court. Then there are taxation issues in the virtual assets. Our income tax regime levying taxes, where an Indian resident legal entity is in the business of running AR or VR platform, the global income of such entity will be subject to tax in India, right. Where a non-resident entity is the provider of AR or VR platform, only the income which is sourced from India will be taxable. Only that which is sourced from India will be taxable. Moreover, goods and services tax may also be applicable on the goods and services provided by the AR and VR platform. Normally, the liability to pay tax is on the service provider, but in some specified cases the service recipient may become responsible for payment of the GST. Crime may also be committed, and there is a real time instance where a woman named Jordan Belmare, right, a pseudonym because her name was hidden, was virtually groped, and she had a very bad experience while she was playing a multiplayer zombie shooter game, when another player who recognized her by her voice began to make gestures that seemed like virtual groping. And Belmare reports that users' behavior, though utterly lacking in physical contact, seems so realistic as to be disturbing. So, should we have such crimes, should we have some laws, or do we have some laws which cater to this kind of a crime, which is a digital groping? We have a concept of digital rape in India, but that has no analogy with the digital groping as happened in this case in the virtual world with a woman, and she felt as if it is realistic or it is physical. Under current law, virtual groping probably would not be a crime. Should the law be changed? I think yes, it should be changed. Nonetheless, she had a very visceral feeling created by virtual reality, and such virtual groping will be highly upsetting to many people, and the more visceral VR becomes, the more it feels to the victim like a real assault. So, indecent exposure, extortion, threats, etc. are also possible in the AR world. Our current laws are not equipped to deal with these offences. Our current criminal laws are not, there are ethical issues and considerations also in the VR and AR, which I think quickly I can wrap up, like so far as the ethical issues are concerned, we have tracking issues, manipulation, right, and even data related issues are there, how end users data is taken away, how they are persuaded and manipulated, right. These are the ethical concerns which we have in the case of AR and VR. Our location, our personal information is taken away, and sometimes we get addicted to such video games. It affects health, mental health, we become excessive obsessive, and sometimes we become victim of persuasive computing, where the technology is used with specific intent of influencing or modifying behaviors, values and attitudes, right. Our safety is at you may say at peril, right. So, these are the key ethical issues, and there are some policy questions. Do we need to redefine public space and reasonable expectations of privacy? Do we need to develop practices for transparency and choice, or do we need to implement restrictions on government use and access of AR and VR, right, or we are supposed to concern take voluntary practices or codes of conduct in this case? My recommendations are that the existing laws and regulations do address the privacy concerns in public spaces, but we need to develop some guidelines to inform transparency and choice measures protecting bystander privacy, develop standardized approaches to government AR VR procurement and use, ensure child protection measures by encouraging innovation while mitigating potential harms. We need to encourage self-regulation and voluntary codes of conduct through a formal multi-stakeholder process. And in conclusion, I will say that it offers an exciting vision of more interconnected, information-rich world, but as more consumers utilize it, more problems are going to arise, and more crimes may going to commit, or more legal issues may going to arise. So, if history is any indication, this transition will challenge existing parameters of privacy and public space, and we will gonna have very worse complications, but answer lies in regulating it, right, through laws, through guidelines, through regulations. So, we need to adapt existing regulations and best practices into AR specific guidelines prevailing across world, so that we may have a very robust regulatory framework to regulate this AR VR technology, which is giving us good experiences, but at the same time poses great danger of being victimized, right. So, with this note, I thank you all, and I will meet you with more such interesting lectures. Thank you very much. Have a good day.